I'll make this brief. Any private organization that has the telos of distributing knowledge and distributing information, which is a conduit for distributing or disseminating information, needs to not have an algorithm, or the algorithm should be exclusively based on what somebody came up with before. If they edit anything or ban anything that is not illegal, they should be held accountable. I don't care if it's legal. I don't care what rights private companies have. If your company is the size of a small country, several US states composed into one company in terms of population, you have unprecedented power and unprecedented responsibility. You have the power to tamper with elections. You are therefore a state actor. You are a government actor. If you are a multinational corporation, you are a government actor. I don't care if it's legal right now. It's the only rational conclusion. There's too much power in these companies. They can meddle with elections too much to not be considered public entities in terms of their effect, their causality. They arguably have more power over the government than the government does. So why should they not be subject to the same regulations? Again, people cite the current law. I'm not talking about the law. I'm talking about what's right. The only thing that stops the Second Amendment from being the First Amendment is the First Amendment. And if a company has more power over the First Amendment than the government does, then they are the holders of the First Amendment. They are the arbiters of information and free speech. And if they won't do that job, somebody else has to. The government's playing second fiddle to the monster it created.